Assalamualaikum warahmatullahi wabarakatuh and salam sejahtera. My name is Hajat Binti Kamarudin with metric number 255812. Today, I will present to you regarding the infographic poster with the title of Mitigating Factors and Aggravating Factors.
There are 5 mitigating factors and 5 aggravating factors. First, we will look into mitigating factors. Mitigating factors usually raised by the defense counsel to the court for the purpose of reducing the amount of punishment imposed on accused. The first factor is age of offender. This factor does not being considered as priority as the judge mostly consider the weightage of the offence and the purpose of the punishment. In the case of Tukiran bin Taib against public prosecutor, the court had opinion that the first offenders that aged between 17 and 21 years old should not be imprisoned but be sent to an approved school like Henry Gurney School, due to them still in young age, causing the court had this opinion. However, this opinion does not follow as the court does not usually give priority towards the offender age, instead more to the purpose of punishment and the gravity of offence. One of the example can be seen in the case of public prosecutor against Lu Chun Fat, where in this case, the accused was released on the bond for a good behaviour due to him plead guilty for the charge of possessing the heroin. However, when the case being revised to the High Court, the learned judge opined that the offence was serious and gave 6 months imprisonment towards the accused even though he is 20 years old and a first offender. The second factor for mitigating is record of offender, where the judge usually will consider this factor before giving the punishment towards the accused, where the outcome from this consideration usually will cause the amount of punishment being reduced. However, this factor also subjected to the circumstances of the case and the seriousness of the offence. In the case of Abdul Karim's against R, the court gave a 400 ringgit fine instead of 3 months imprisonment due to the accused being the first offender. This shows the clean record of offender can cause reduce in amount of punishment imposed towards accused. However, this does not apply to all cases. In the case of public prosecutor against Ong Lee Swing and others, where the offence involved is drug trafficking, this clean record does not give effect in reducing the amount of punishment due to death penalty punishment is mandatory for this particular offence. The third factor for the mitigating is plea of guilty. This factor is a strong mitigating factor for the judge to consider, as it saves the time and the cost for the court in handling the case. The accused usually will get reduced amount in his punishment as a form of consideration when he plead guilty. In the appeal of Zaidun Sharif against public prosecutor case to the High Court, the court lays guidelines relating to sentencing of accused, where the court stated that it is an accepted rule of practice that the accused should be given credit or discount for pleading guilty, which the amount of the punishment given not according to the maximum imposed by the law, but on sentence which would have been imposed if he had claimed trial and had been found guilty. However, this rule is not an obligation to be followed, as the court still can exercise his discretion in not granting the discount, where it usually based on the circumstances of the cases, but must give reasonable justification to that. The court usually will not granting this discount in the case where the offence was serious and grave even though the accused had pleaded guilty. The fourth factor for the mitigating is the gap principle. This factor can be used where there is a gap between the accused's last conviction and present conviction. This usually been taken into consideration by the court before give a punishment towards the accused. Based on the case of Su Sanaitan against public prosecutor, the court held that the longer the gap, the greater the mitigating effect. It was opined by the court that the court looks onto the positive steps that the offender had taken to rehabilitate himself in order to become a good man from the previous conviction, and not looking solely at the time lapse between the current and previous conviction. The last factor for the mitigating is the condition or circumstances before commissions of offences. In this factor, if there exists certain condition or circumstances before commission of offences, the court will consider that before giving sentence towards accused. The example of condition may inform like provocation, drunkenness, consent and other conditions that related. This condition may work as defences for the accused in regards to the offences due to it does not come from the accused itself. For example, the provocation that stated in the case of public prosecutor against Ahmad Khairul Faiz bin Mat Dahlan and others can be raised as defence to murder in a mitigation. The provocation must be proved to be balanced between the degree and nature of the provocation and the act of the accused in order to raise these factors successfully. Now, let's move on to the aggravating factors. There is 5 factors in the aggravating factors. Aggravating factors usually comes from prosecution in order to pressing the court to give heavy sentence towards the accused. The first factor is the prevalence or rampancy of offence. This factor is looking based on the category of offence. Offence like drug, kidnapping for ransom, rape, theft, robbery, housebreaking and firearm is an example of offence under category of prevalence or rampancy of offence. According to the case of public prosecutor against Tan and Hawk, the punishment that the accused get in this case is that being released on good behaviour for the offence of stealing a car. However, when this case is being appealed, the court considered the rampancy of the offence and made decision by substituting the bond with a severe punishment which is 18 months of imprisonment. The second aggravating factor is previous conviction or bad record. The court also will consider this factor before giving the punishments toward the accused. Records of previous conviction usually being prepared by the prosecution in order for the court to look onto it before giving the sentence. This can be seen in the case of public prosecutor against Jafar bin Daud, where the learned judge had opined that, in looking onto the previous conviction of the accused, the court will first make a consideration in regards of the similar nature of the previous and current offence. Besides that, the court also will look onto the previous punishment in order to see whether the punishment given before give deterrent effect or not toward the accused. If the punishment does not give any effect by looking at the number, the similar offence is being repeated, then the court have power to give severe punishment to the accused. The third factor in the aggravating factor is the position or status of the offender. In the cases where the offender hold a title in the name or a respected position, this factor can be used as an aggravating factor for the court to increase the punishment. For example, in the case of Datuk Haji Harun bin Haji Idris and others against public prosecutor, the offender, who is a Menteri Besar Selangor, had been given sentence to 6 months imprisonment for the offence of forgery and a fine of 15,000 ringgit for the offence of abatement of a criminal breach of trust. The case then been brought on appeal, where the deputy public prosecutor used his status against the offender in order to get the court to impose heavier punishment towards him. The federal court had increased his punishment by giving 4 years imprisonment for the first charge and 3 years imprisonment for the second charge, which this punishment run concurrently. The court opined that, due to the accused hold the respected position of a leader in the state government, he should have shown a good example towards other people. The judgment of this case was then been referred and confirmed in the case of public prosecutor against Datuk Tan Ching Swee and another, where the learned judge in this case stated that high status as offender will aggravate the offence. This can cause heavier punishment to be given to the accused. The fourth factors for the aggravating factors is use of force. This factor will be used in the case where there is a force or violence used to commit the offence. The existence of this force usually will cause a very heavy sentence and whipping imposed on the accused. According to the case of public prosecutor against Safian bin Abdullah and another, due to the mortally wounded victim was brutally strangled with a rope, the learned judge had imposed maximum sentence of 14 years imprisonment toward the two accused. The last factor for the aggravating factors is mode of committing offence. In this factor, if there is existence of brutality when the accused is doing the offence, then the court will impose heavier punishment towards the offender. This can be seen back in the case of public prosecutor against Safian bin Abdullah and another, where, due to the existence of brutality of the two accused towards the victim, causing the court impose maximum punishment towards them. This also can be seen in the case of Joginder Singh against public prosecutor, where the act of the accused in planting the dangerous drug into rival restaurant and pleaded guilty to the charge under Section 211 of the Penal Code had caused him to get 2 years imprisonment from the court. In appeal to the sentence, the learned judge in appeal court had upheld the sentence due to the act from the accused will cause the innocent person to be convicted unfairly.
In conclusion, from the points in the infographic poster, it can be seen that mitigating and aggravating factor is an important factor that need to be raised in criminal cases before the sentence can be made by the court in order to make sure that the punishment given is fair and just. That's all from me. Thank you.